Mr. Evans has indicated that he'd like to represent himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording though.
Okay, so will it be on record and
Yes.
Will it be able to be reviewed by federal judges if it gets to that or whatnot?
All right, before this hearing spirals into sovereign citizen chaos, let's break down what's happening here. We're entering a courtroom in Washington state where Mr. Evans, the defendant, has elected to represent himself. For anyone unfamiliar with the sovereign citizen movement, it's a fringe ideology built on the belief that government laws don't apply to them if they invoke certain magic words like tribal sovereignty, ancient treaties, or maritime law. Spoiler, none of it works. Judges see it almost daily, and it typically backfires spectacularly. Right from the start, Mr. Evans claims he mailed a letter containing sensitive sovereignty information, insists that everything must be documented for federal review, and begins invoking legal protections that simply don't exist. What makes this case extra spicy? Mr. Evans isn't just here to argue. He's filed lawsuits against judges, courts, and even corporations, behavior that's given him a reputation for legal theatrics. But representing yourself in court is already a challenge. Doing it while relying on pseudo-legal tactics and unverifiable tribal royalty claims? That's a recipe for disaster as we move through this hearing. Pay close attention to the judge's patience, the defendant's contradictions, and how quickly sovereign arguments fall apart when asked for real evidence. Trust me, you'll want extra popcorn for this one.
Okay, I can read a copy of the letter. I mailed the letter out. There's no reason it shouldn't have reached you, but the letter had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. It's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoke my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part and the getting the proper defense. And then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, I humbly, respectfully ask that you give me a PR bond so I can at least properly defend myself, especially that I invoke my rights as a tribal chief.
Here comes a classic sovereign citizen pivot, requesting a PR bond or personal recognizance bond based on vague references to sovereignty and tribal leadership status. Defendants do have the right to argue for modified bail conditions, but courts grant them based on concrete criteria, like employment, residency history, criminal record, and flight risk. None of those include I'm royalty or I mailed a letter with secret evidence. The judge also points out a critical issue. Nothing he claims is supported by documentation. If his mail didn't arrive, that's unfortunate, but courts don't adjust rulings based on unverified claims. In invoking a treaty with Morocco, judges have seen this 1,000 times. It's legally irrelevant and immediately signals pseudo-legal tactics. The judge stays calm, but patience is already thinning.
I believe we've already had multiple bail hearings. I'm sorry, Madam Clerk, you were saying?
I was just gonna say that there was a letter that was faxed in that we received yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
Okay, I've read your letter. You've already had at least one bail hearing, because I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No, so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me. I assure you.
You can't be a royalty in Morocco and a Native American. That's not possible.
And there it is, the infamous Morocco Peace and Friendship Treaty. Sovereign citizens love referencing this document, believing it grants diplomatic immunity, special legal status, or exemption from U.S. criminal law. In reality, as the judge correctly states, it's a trade agreement, nothing more. It doesn't create royalty, immunity, or special privileges for private citizens. Notice how, when asked which tribe he leads, he suddenly can't say, because if he names one, the court can verify it. Sovereign arguments often collapse at the first request for specifics. His attempt to simultaneously claim Native American tribal leadership and Moroccan royalty creates a contradiction that does not legally coexist. Courts require facts, not fantasy.
If you look at the evidence that I submitted, I assure you I am.
I received no evidence. I received just your letter.
Right.
So I'm not going to.
And the letter.
I'm not going to grant your motion to dismiss.
Okay.
What are we doing?
Okay. And I submitted evidence in the letter.
I'm not denying. I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter, and I'm not granting your motion to dismiss.
I understand.
Okay. What are we doing?
What about the evidence?
What do you want me to do with the I don't have any actual evidence. I have your statements.
Right. I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted you mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of St.
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You
is
have to retrieve it.
I have no way to do that.
You have
That's
to
not your
contact the
job.
courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job. I ethically cannot do investigation on my own.
No, I'm not asking you to do an investigation.
We just hit a major sovereign citizen stumbling block. The defendant insists he submitted evidence, but the judge has not received any physical documentation. Mentioning a civil court case in a letter doesn't make it admissible evidence. When representing yourself, you are responsible for properly filing exhibits, requests, and discovery motions. The judge can investigate on your behalf. That would be unethical and a violation of judicial neutrality. His argument quickly becomes circular. He can't get the evidence because he's in jail, and therefore the court must retrieve it for him. That's simply not how criminal procedure works. Sovereign citizens frequently misunderstand the difference between claims and evidence, and it's costing him here.
You're asking me to go retrieve something. That's an investigation.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel. Perhaps you can talk to him about it.
Are you going to be able to retrieve that case for me?
1 second. And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The case has a seal on it, and you're going to have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the U.S. Supreme Court has to do with a Louisiana state case.
Because it holds my rights, as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief, in which I represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not going to dismiss it, I asked that in the letter I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain. And some of these cases are in review status. They've already been resolved and found guilty.
Okay, and also in those review cases, I said if the
Sir, I'd really like to focus on what we're doing today. I've denied your motion. We need to move on.
Yes, ma'am.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress.
Sir, you represent yourself. You have to file those motions. Nobody, you asked to represent yourself. You got, Judge Rose Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions. So I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one? Okay.
I just clicked on it to give him an example of that order as well.
No, I think you've got all the right ones on here.
Okay.
1-5.
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
You
my
have to file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like I don't have any access to the law library.
This portion highlights another common issue: misunderstanding jurisdiction and authority. The defendant claims the U.S. Supreme Court Chief Justice must approve the unsealing of a Louisiana state case involving tribal sovereignty. That is nowhere near accurate. Chief Justice Roberts has no legal authority over sealed state records. Each state manages its own judicial records, and sealed documents require motions within that court. Additionally, tying a sealed Louisiana case to royalty status in Morocco and tribal rights in Washington creates an incoherent legal narrative. The judge remains composed, but she's essentially untangling fantasy logic in real time. Notice how she keeps steering him back toward practical steps. File motions, present evidence, follow procedure. Without that foundation, no amount of sovereign language changes the outcome.
I gave him the narratives.
Police reports, that's it.
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try, if you're not going to agree to try them simultaneously, I can't guarantee you they'll all be tried we only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
I just explained what joinder means and the benefits and disadvantages of joinders.
So, Mr. Evans, what do you want to do?
I want to do them all separately.
Okay. We'll set them, here's what I'm going to suggest then. I'll put this out to you guys. You tell me what you want to do. Set them all in the June term, and then whichever one goes. But we'll have them all set so that it'll depend on who's available and such. Okay, but they are not joined. That unless somebody files a motion, I actually hear it. But as of now, nothing is joined. Okay.
Yes, Your Honor.
So the readiness hearing will be on June 12th.
Sit out here.
And jury trial beginning the week of June 24th. And we'll have a hearing on admissibility we'll have a 3-5 hearing. That's a hearing about any statements you may have made, Mr. Evans, and a hearing on admissibility of any 911. I don't know whether there is or not, but just in an abundance of caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses you'll be calling?
Yes, ma'am. I would like to subpoena the airport director or the operations airport so I can have those guys verify that I was there. The reason I was there is legal airport business.
Ms. Chenwaller, is including SeaTac airport operations sufficient to put the city on notice of who the defendant will be calling?
No.
Okay. What would you accept? I don't know how to put this because I don't think Mr. Evans knows who this is right now.
I believe the onus is on
director
the
of the
defendant
airport.
if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. SeaTac Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
Yes, ma'am, I do. I will be providing an affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Well, also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying I didn't do it. Not an affirmative defense is saying you did it, but there was that you were allowed to do it.
Right. I was at the airport, and the reason why
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit any crime.
no, I'm saying that I was a customer of the airport.
At this point, the judge is gently, but firmly, explaining Criminal Procedure 101. If a defendant wants something sealed, suppressed, or dismissed, they must file formal motions using specific legal standards. Simply requesting something in conversation or writing it in a letter is not enough. When she references the Bone Club case, she's pointing him toward actual legal precedent governing courtroom, transparency, and sealing documents. His complaint about lacking law library access is legitimate, but representing yourself still requires meeting procedural requirements. Judges cannot bend rules, babysit filings, or ignore established case law. This is why public defenders exist. Navigating these systems is extremely difficult, even for trained attorneys.